Hello, everyone. Welcome to week 4, the final week of the Trial by Peers Summer Course 2020. Mike, Felicia, you're probably sick of seeing us by now. This is the fun week. This is what trial prep week. We're going to be covering witness preparation, witness questioning, objections, all the good fun trial stuff, and then we're going to close with opening and closing statements. So, let's talk about witnesses to start. I know in the previous class we discussed witness selection and how to start going about that, how you want to think about putting your witnesses on. So, your first question to yourself when selecting witnesses, does this person help my case? Now, if a witness isn't going to provide anything to you, then you don't need to waste the time or energy in putting them on. So what you want to think is, what do I want to get out of this witness? What information is this witness going to provide to my case that's either going to help my case or hurt the other side? If a witness doesn't provide any information or doesn't damage the credibility of the other side, then should you really be calling that witness? The best way to think about it is relevance. So I gave you an example in the previous class about the football analogy. Does the witness move? Does the evidence move the ball? If you're not moving the ball one way or another, you shouldn't put that evidence in. Therefore, you probably shouldn't put that witness on the stand. We also discussed credibility a little bit, and is this witness credible? And this is where you're really going to need to pay attention to and prep your witnesses. If you have a witness who, when you're working with them, doesn't really appear to be believable, let's just say they're doing the shifty eye thing when they talk, which I'm probably sure we're all doing in these videos right now, or they don't appear to be confident, you might not want to put that witness on, because at the end of the day, that witness is going to help convey your point. And if you think it's going to hurt your case to put someone on, they may be telling the truth, but if they just can't testify without appearing trustworthy, that may hurt your case. So that's something that you as an attorney have to decide whether or not it's a good idea to do or not. And we discussed a few things before about credibility, but I'm going to go over them again. Bias. Is your witness going to appear to be too biased? Are they super best friends with your client that's the defendant? Is it going to look like, I can't believe this person because they're going to say anything to help their client? Or worse, maybe it's if you've got a case where it's like a theft or a fight, if you're going to put the victim's parent on the stand, are they going to say anything to make sure that their kid looks like that, oh my God, my kid got beat up, this person needs to be convicted? So you need to think about that before you call witnesses. You also want to make sure that you when you're prepping your witness, that if they've got any sensory issues that we talked about, vision, glasses, make sure you're wearing glasses now. Did you have your glasses on at the time of the incident? Were you listening to, did you have your AirPods in while you were, when you said you heard this noise? Make sure that you clear those things up, because you don't want the defense or you don't want the other side to bring that information up. I always say the defense because I'm a prosecutor, so it's not biased. I have bias. There you go. So make sure that you think about that when you're talking to your witness, because the other side may bring that up, and you don't want that to come up in the middle of a trial, and you're like, oh crap, I didn't think about that. Now I'm in trouble. Now I have to recover.
Wait, so Mike, what should they do if they have these kind of questions and they don't know who to call or how to handle someone they feel could be biased?
Well, I think the best person to talk to, Felicia, is they should call their senior attorney, because their senior attorney can help. But if you have a co-counsel, you may want to talk to them too about getting some ideas and seeing if maybe your co-counsel's got some ideas, and then you can go to the senior attorney together. But always call your senior attorney for questions. That's what they're there for. They'll be able to help you. And if you think you can't, let's just say you don't think you can get a witness on, well, maybe the senior attorney can help you. Okay, this is how you can make that witness look more credible, or here's something you might consider. So your senior attorney is always going to help you with things like that.
Good.
So another thing that you want to look for with witness selection is making sure that witness has personal knowledge. We talked about that in the last class. You want to make sure all your witnesses have personal knowledge of what they're testifying to. That's very important. So the last thing in witness selection is your analysis of your witness. We covered this a little bit already, but it's really important, and we're going to get into this here in a minute with witness prep, that as you're prepping your witness, you may come to realize, I don't want to call that witness. So if that witness has had a key piece of information then that's where your case prep knowledge is going to come into play. Let's just say you have a hard piece of evidence and you've got this one fact and you need this fact to get in or else you can't prove your case. And you find out that your only witness that has that fact isn't going to be able to convey it well. So we'll ask Felicia, what do you think? So if you've got one fact for your case and you can't get that witness to testify it correctly, how would you handle that?
Well, it's just like we talked about in case strategy and preparation. I'm going to prepare. I'm going to go over it with them. I'm going to do what we call in the real world pre-trial. I'm going to go over what that witness knows. I'm going to go over any apprehensions they may have about testifying in front of people. I'm going to talk to them. That's why preparation, so much of trials in your preparation points. And so I'm going to make sure, and if I have questions, I'm going to talk to someone who's done a trial before. If my senior attorney is available, I'm going to be talking to them. And if they're not available, I'm going to find out when they are and make sure that I know from someone who has done a trial, I need this in. How do I get this in with someone who might be either apprehensive or stumbling over their words or not able to communicate? What is it, what made them seem unbelievable to you? And so you can correct that with some prep.
Now, every once in a while, you may come across something that you can't get in. Let's just say you thought you had a witness that saw something, and then you find out that's not the case. That somehow when the case got from the juvenile division down to trial by peers, something got lost in the translation. It's your job as an attorney, and we're going to definitely talk about this, when we kind of cover ethics and things. You may have an ethical obligation to, especially if you're the prosecution, say, I don't have enough evidence to take this case on. So that's when you definitely need to talk to your senior attorney or talk to the trial by peers program or both. You may have to dismiss a case. I believe Felicia was the judge in a case where we had a case that the defendant said he was read his Miranda rights, but then come to find out he was read them in English and he didn't understand English. So the prosecution in the case, they rightly went to the judge, Judge Quinlan here, and said, "Hey, we can't try this case. There's some rights that have been violated," and the case was dismissed. So you have to think about those things when you're, on the fly with cases. But talking about what Felicia said with preparation is the lifeblood of trials. There are no there's not a lot of aha moments. There's not a lot of Perry Mason. I heard Felicia talking to you guys in a previous class about there are those moments almost never, if ever, happen in a trial.
And why don't they happen? Because it's not fair. So remember, when you're doing trial prep and you're going to put on a trial, that's so important. I know I've talked about it before, but the underlying principle is it fair?
That's correct. So let's talk about witness prep. What's the first step in witness preparation? And believe it or not, it's, do you have all your witnesses? When we talk about prepping your cases, then we talked about this early on in the summer course with just case prep itself, is you want to lay out your case strategy, and your case strategy is going to have a list of facts. You need to make sure that you have a witness or an exhibit that's going to get every one of those facts in. So make sure you have everything. So that's step one, is do you have enough witnesses and exhibits to prove your case? Because if you don't, especially if you're the prosecution, you may not be able to prove your case if you get to trial and realize, well, I don't have a witness that can testify to this key piece of information, and that may blow your whole case. So that's step one. Step two for witness prep is actually practicing with them. And that's something that even in real court, sometimes you just don't see it. And when you get to trial, you can definitely tell which witnesses have been prepared versus witnesses that haven't. What is key when practicing with your witness? Number one, is your witness capable of testifying to the facts that you need? And that covers a wide range of things. Again, personal knowledge, we've said it 50 times, you're probably going to hear it 50 more. Do they have personal knowledge? Can they convey the point or piece of evidence you actually want. And that's where practicing with them comes into play. When I practice with my witnesses, I tell them, here are the 5 or 6 facts, or even the one fact. I need this to get in. We're going to practice how to get that. Because number one, it helps relax your witness. Number two, it gets them in the rhythm of how regular court's going to go, which again, therefore relaxes them. So you want to make sure that you're practicing with them, because the more relaxed they look, the more credible they're going to look. So you may have somebody who's telling the honest truth, but if they can't do it in a confident manner, a jury may like, well, they look like they're really digging for their answer. Do they really know it? Are they really telling the truth? Or are they kind of making it up as they go? All of that gets done because you're practicing with your witness. Getting back to just techniques and practicing is kind of giving a roadmap for your witness. So when I prep a witness, I tell them, I kind of go over the highlights. So I'm going to kind of get into your basic information. And once I get the basic information, or the foundation, getting back to a previous class down, I'm going to start asking you specifics. So for instance, in our cases, we do what's called child welfare. So we have workers for the state. And my first set of questions, and it's to both relax the witness and lay the foundation, is, okay, what do you do as a job? Tell me your name. Tell me your occupation. How long have you been at that occupation? What position are you in the occupation? How long have you been in that position? Which is establishing that they know their job, they've been there for 12 years, they're experts at it at that point. Okay, so tell me, you have a role in this job that does this. Tell me about that role a little bit more. And I'm not even talking about the main case. I'm talking about their job in general. And once I get that all laid out, then it's, okay, you worked with this person, right? Tell me about that person. And then you get into it. And what that does is that relaxes the witness in practice, so they know what to expect in court. And then when they get to court and you start asking those questions, they're like, okay, well, I've been through this before, so it's not that big of a deal, which then again makes them look more credible. So at the end of the day, you're practicing so your witness, one, knows the answers that you're looking for, or two, is making them relax, which is going to make them remember their answers more, and it's going to just make them look better in court. And that is the key to witnesses and making sure they're ready. Do you want to add anything to witness prep before I get into just one technique?
The only thing I would add is, if you're talking to a witness, before you go over what Mike's right, go over highlights, go over this is what I'm looking for, let them tell their story first. That's important, because you're going to want to know how they perceive everything that happened, and I let them tell their story first, take notes, and then we go over, these are the highlights, these are what I wanted, this is what I heard you say, and this is what I want to focus on when we get it into court.
That's actually a very good point. And sometimes the way our witnesses, we don't always get to do that. And with your guys' witnesses, that's very true. You're going to tell me your story, and then let them go. Let them talk as long as they want, take notes, and then start picking their story apart and with a thought of, here's how my questions are going to go.
Right. So now that you have your witnesses all prepped, we're going to go through, how do you actually question them? And the number one thing is, we both want you to remember, is wholeheartedly be relatable to the jury. Use common language. I know you want to sound smart, and I know you're all very intelligent people, but you leave your 50-cent words at home. Make sure that you are understood. That's really important, because if I don't know what you're talking about, I am not listening to the answers. So I'm basically trying to figure out what you just said. So make sure that your language is understandable, is relatively simple, no legalese, standard English, and then use the less is more technique. And listen, every attorney practicing here and everywhere is guilty of this at times. Sometimes you did all this prep, right? You made sure that you know everything inside and out. You'll ask a question that makes sense in your head, but someone who's never heard any of these facts before would say, okay, what are you talking about? I don't understand. So make sure that you're understandable, very basic questions. Basic. Remember that. That's really important. Let the witness tell the story. Don't try to tell the story for the witness. You want them to, at least on direct examination. Okay. So let's talk about direct examination.
Before we get on direct examination, there is one thing I want to bring up, which gets back to what Felicia said about being relatable in the courtroom. remember who your jury is. Your jury is going to be mostly comprised of people that have already gone through this program and are serving part of their sentence. So there probably are going to be a little more, if you're on the prosecution side, there may be a little against you already, so you need to make sure you're relating to them. The defense, you kind of have an advantage in this case, in this point, because you're basically, your jury is 12 to 18 defendants essentially. So that's why it's very important to relate to who you're talking about, because you want to make sure that the lessons are being learned both by whomever is in the defendant's chair, and that the people in the jury are still technically kind of learning their lesson, if you will. So you're in a very unique position as a trial by peers attorney, that you're affecting essentially you're talking to jurors that are still kind of serving out the sentence for what they did. So it's just very, like Felicia said, it's very important to be relatable, even more so for you than it would be for a trial attorney, where you want to make sure that no one has any kind of bias towards the case. You're dealing with kids who've basically just got done with their trial 2 or 3 weeks beforehand. So it's just important to relate.
So as you're going through your questions, the number one rule of being an attorney, and I've actually been accused of this in real life, is never ever ask a question that you don't already know the answer to. Like, guys, you did all this prep work, you did all of this practicing, you wrote everything out, you know this case. Make sure you don't ask anything just out of curiosity, because you never know what you're going to get, and you never know how that's going to impact everything else. One wrong answer can really have an impact. Make sure you know every single answer before you ask that question. That goes back to what we talked about no Perry Mason moments. Everybody already knows it, okay? Everybody but the jury, and that's who you're talking to. And then make sure you pay attention to the witness's answers. There's nothing more frustrating than listening to a trial. I do a lot of judging, so listening to a trial and realizing that the attorney is just reading off a list and not even hearing what the witness says. Okay, you don't want to be that person. You want to hear what they have to say, and if that means making an adjustment, you can make an adjustment. Right here is where I want to stop and say, hey, as a judge that listens to these trial by peer programs, and as an attorney who does trial work, you need to know something. It's called asking for a moment of court's indulgence. If something came out and you need to deal with that, that's all you have to say. Remember those words, write them down, commit them to memory. If I've said them to you already before, write them down again. Your Honor, may I have a moment of court's indulgence? No one's ever going to say no, okay? And what that allows you to do, confer with your co-counsel, who's hopefully been listening to everything and taking notes. Confer with your senior attorney. Find out what that person just said, how that impacts your next statements and questions, and what you're going to do. Okay? Never, ever, ever, ever be too confident that you don't need a moment to collect yourself. Okay? So with that in mind, how do you do a direct examination? How do you get that information in front of the jury? Because the whole point of a direct examination is to lay out the facts that you're going to use to argue in your closing later. So you need to get those facts out, and it's really important to make sure that they are presented in the voice of the witness, okay? Remember what I said, no legalese, basic questions. Make sure that your witness is actually it's so much more believable when a jury of your peers hears words from a teenager that a teenager in that position would say. You don't want to feed your witnesses any answers. You don't want to feed your witnesses anything that you perceive to be what the answer should be. You want them to tell you the whole story.
In fact, it's an objection, which we'll get into later. It's called leading the witness.
Okay, so on direct examination, you're not going to be leading. You're going to allow that witness to tell the story. Sometimes it can get into a narrative. We'll talk about that in objections, but that's the idea. The more, you should be talking less on direct, and your witness should be talking more. That's your key thing to remember. Who is talking more during direct examination? The witness. If you find yourself talking more than the witness on a direct examination, what do? Ask for a moment of court's indulgence and redesign your questions and get that fixed, okay? Absolutely want the witness to be doing all the talking.
That's also something you can practice too. We talked about this before, and I don't want to cut Felicia off, but probably. But that this is where practice comes in, and we'll talk about this more in class because you can ask the same question in both a leading fashion and a non-leading fashion. So I just want to bring up practice. Practice makes perfect. Sorry.
Right. Okay, so there are 4 stages during direct examination. We're going to go through them really quickly. Stage 1, background information. So this is what okay, so there's 2 meanings of the word foundation. Foundation can be laid for admitting an exhibit, as Mike talked a little bit about exhibits last class, but foundation is also the foundation for a witness, okay? Foundational questions. So you get a police officer on the stand. What is your name? Where are you employed? Police department, right? Either school police or metro or something of that sort. Were you working in that capacity on such and such date? Yes. In the scope of your duties, did you come across this person? Yes. So lay all of the foundation, okay? What has bothered me as a judge listening to these trials is to hear someone say, were you there on the day in question? And the witness is trying to help you because they know that this is a diversionary program and they're going to say yes. And my mind is thinking, what the heck are you even talking about? When is the day of question? Where is what you're talking about going on? The foundations are the when, where, who, where again. Make sure you know it's here in Clark County, it's here at school, or it's at someone's house. This is foundation. You've got to get that background info. How does this person know? Okay, how do you know? Don't say, how do you know the defendant? Don't say, how do you know the subject matter? Don't say, how do you know the person? Use names. How do you know Paul Jones? How do you know? You've got to lay that background information. And the best way to do it, because I know that you're going to write out all your questions and be totally prepared as Mike just went over with you. But make sure part of that prep is who are you and how do you know this stuff, right? And then when, where, why, okay? The next stage of witness questioning is the pre-event questions. So you got to do some lead up. You got to do some build up. So this is the part where if we were having a fight in the 700 hall of the class of the school, this is how you put, okay, what were you doing beforehand? How did you get there? What the heck is the 700 hall of the school? That kind of stuff. Make sure that you have the pre-event questions so that you have some good information leading up. And guys, at your school fights, disturbance at schools, this is really important. Before you get in a fight with someone, 90% of that stuff, the important stuff, is what happened right before. So you've got to get that info in. You can't just start. It's like those videos that start right when something's happening. And well, you didn't see what happened before. So you want to present that to the jury. They're going to want to know it. They know as well as you do, 90% is what happened right before. Okay, so get the pre-event questions out. Let that witness tell you what happened leading up to the event. So of course, stage 3, the next stage, are the event questions. So it begins at the point of no return. So that's when you click on the video. That's when the punch is thrown, right? The fight starts. That's the event. And you can go through what has happened in that event. So if it's a crime, it's the beginning of the smoking marijuana, the beginning of the vaping marijuana, the beginning of the possession, when the person handed it to you. That's the event. That's when that information is going to go through, okay? And make sure that your witness details all of that event, okay? And the event's not done until the crime has been completed, okay? So that's the event. Stage 4, post-event questions. So sometimes this doesn't apply. Sometimes we're done. Sometimes it does. Sometimes there's some extra info because sometimes you can, and remember we talked about intent a couple of weeks ago and all the different ways to have intent. Sometimes intent can be inferred by the actions that happened afterwards, okay? If you intended to fight when you got up and you were not sorry and you didn't care and you just walked away, that can show intent before pre-event intent with post-event actions. So sometimes they're important. If you have questions, make sure that you ask your senior attorney about where to put that in, but definitely plan to get some post-event info in if you've got that good info. And how do you get the good info? With your prep, with your witnesses, okay? And making sure that you know everything they know before the trial starts. And then cross-exam.
Pre-event, post. Can you say that one more time? Because I'm confused.
Sure. It's step 1 is background. Okay, that's how they would know that info. Stage 2, pre-event questions. What's leading up to the event? Stage 3, the event, the big main event. Stage 4, post-events. What things did they do afterwards?
Awesome. I liked your explanation of the post-event can give you pre-event information. Because I honestly, and I've never thought about that before, so that's a good point. So I learned something today. So let's talk about cross-exam. So if I'm ever your senior attorney, or actually for sure Saturday, you're going to come to the conclusion that I love cross-exam. I took an entire semester on cross-exam. It's fun. And I will teach you on Saturday how to mess with your friends with cross-exam. My fiance hates me for cross-exam. I cross-exam her at home and she gives me the look and then I have to stop talking. So this is fun. This is actually, in all seriousness, this is where you have fun as an attorney. You're the one testifying now. So on direct exam, you let the witness say all you want. You're kind of just lead them down the path. Cross exam, you're in charge. You get to run the show.
Can we just break real quick
Of course.
right here and say, sure, it's super fun and you get to be super aggressive, but just make sure you understand there is such thing as overdoing it.
Yes. Yeah.
And you can turn people off by being too aggressive and too aggressive that turns into angry. And why is that person so angry? And now the jury's focused on you and not what you're getting at.
Yes, there's a tactful way to do it, and we will show you how to do it. And we'll show you how to not do it, because that is a very important thing, and I did not write that down for this, but it's a very important point to bring up. So you can definitely be very effective at cross-exam without looking like you're being too aggressive. Because you got to remember, your jury's paying attention to everything you're saying. So if you look like you're badgering someone, it's going to come off bad. So what is cross-exam? So that's when, if you're a defense, you're representing the subject minor, you get to ask your client all these questions, and then the other side gets to get up and ask them questions. How do they ask those questions? It's what's called leading questions. So unlike direct exam where you want to use non-leading questions where you're letting the witness tell their story, you're the one who's basically, you want to ask yes and no questions. You did this, didn't you? Yes. You did that, didn't you? Yes. You saw this happen, didn't you? You're the one, you just want them to say yes and no most of the time. There are different ways. There are a couple of ways that you want to actually have a witness answer a question in more of an open-ended format, but usually, and that's a technique we can show you, but that's when you don't really care what they say because either way they answer is good for you. But those are fewer opportunities to do that than just asking them yes or no questions. Like one reason you want to ask the yes or no questions, you want to keep your witness in a rhythm. That way you're in control. So you almost want to start off by asking them some very basic stuff. You want to get them used to saying yes or get them used to saying no. So that way when you get to those questions, the heart of your cross exam, they're already used to saying yes or no. They're just going to go along. They're not going to give it. They're not going to say, well, but let me, no, nope, yes or no. So you want to get them in that rhythm early. While everything in trial is about knowing what your answer is going to be before you ask it, cross-exam is very important to where you do not ask a question you don't know the answer to. And the reason is because there's really not a lot of ways to go back. Let's remember we said about relevance, once the bell is rung, you can't unring it. This applies here in cross-exam too, because unless you have something you can impeach them with, you've lost that point. So this isn't like TV. You're not gambling for the big answer. You're not looking for the smoking gun. And most importantly, you need to remember this. You are trying to win the cross, not the trial. While trial by peers only has a few witnesses usually, you still have to remember that each witness is just a part of your entire case. And you're building your closing argument with these witnesses. So for each witness, when you're prepping to cross-examine that witness, you want to look, what do I need out of these people? What information do I want to get? Or what information do I want to ruin their credibility on? And there may be times where you don't have to. And if that's the case, then don't ask a cross-exam question. Just because someone's got 100-question cross-exam, which you should never do in trial by peers, by the way, it doesn't mean it's effective. In real life trials, my best cross-exam question, I asked one question. And it was done. So just remember, don't ask questions just because you can. Another important part about making sure you want to win the cross but not the trial with your one witness, do not argue with your witness on cross-exam. That's going to make you look too aggressive, number one, and it could just ruin your case. So if a witness answers something incorrectly, or if they lied and you don't have a way to impeach them, you just have to move on. You just have to take that loss and keep going, because if you start chasing it, it's going to become even worse for you.
And never ask, are you sure?
That's correct.
Right, because you know the right answer. And if you didn't get it, just bury it with more questions. Don't highlight it by asking things like, well, are you sure? Or didn't it happen this way? Just be careful.
Yeah, the only time you can do that is if you know you can impeach them. And we'll get into it. There's a
I said you just said they don't have anything to impeach them with.
That's fine. Okay, I'm sorry. Well, if you don't have anything to impeach them with, do what she said, which is don't do that. But we do have techniques where you can kind of tactfully mess with people. Cross-exam is all about preparation. What do you need to get out of the witness? What fact do you need? Get in, get out. So you're looking, just like you're preparing your own witness, and how do you prep for that witness? You want to look at their previous statements. If you probably won't have a chance to talk to their witnesses because of how trial by peers works, but you'll get their statements that they gave in police reports. So you'll have an opportunity to look at things they've already said, and they may have said something in a police report that you think is helpful, that you want to emphasize as a fact. Or, and this might be more prevalent in trial by peers, they may change their story. So that way you can go up and just say, well, you said on direct exam you saw this, but isn't it true you really saw this? And that's when you can potentially impeach them. So your key part in prepping for cross-exam is reading everything you get in your evidence packet, because that's going to tell you what you're looking for each witness. So before we move on to some more witness techniques, is there anything you'd like to bring up about cross-exam? Okay.
One big thing on cross-exam is don't ask that last question. Think of it as, because you prepared, you wrote out your questions, you're ready to go, and you want to ask, well, you didn't believe him, did you? No, nobody is going to think about it. When your parents ask you, you did it, didn't you? How often do you say, oh yeah, I totally did. Take my phone away. No, nobody does that. Don't ask the last question. That is kind of the mantra of cross-exam, is that you want to leave the jury going, wait, if this and this and this, then let them make their conclusion. Argue it in closing, but don't try to get your witness to admit something against their own interest. They won't do it, and you run the risk of strengthening the other side's position, because they're going to adamantly deny something that's against their own interest. Don't ask that last question. Save it for your argument.
A perfect example of that is like fight cases. You're not going to walk up and say you meant to fight him. You meant all day long you wanted to fight him, didn't you? Because they're going to say no. But if on cross-exam it's like, well, you said something earlier that you had issues with this person. Yeah. You talk to other people about being in a certain place at a certain time and waiting for that person. Yeah. And you put all these pieces together, and that's when, like Felicia said, in your closing, then you say, well, look what happened. Steve talked to was making threats about this person to his friends earlier in the day. He said he was going to be waiting for someone, and he was, and this happened, and this happened, and this happened. And that's how you prove the intent. And that's what's like, well, if they did all these things, knowing it would result in a fight, and then you let the jury put it together.
Remember our intent lessons. You can let the jury make that conclusion.
Yes.
Okay?
So, would you like to discuss refreshing memory?
So
because I forgot.
Other techniques
Bad joke.
I know, right? Do I need to refresh your memory?
Yes.
Some other critiques for direct examination, and this comes in when you're prepping your witnesses. The really big difference between I don't remember and I don't know. There's a huge difference between I don't know and I don't remember. Why is that important? Because I don't know means something that you never knew. Like, what color was my shirt yesterday? You don't know. And you never knew that. But what did you eat for breakfast a year and 1 day ago? Well, you knew that at the time. You just don't remember right now. Make sure that when you prep your witnesses, you make that distinction, because here comes refreshing the recollection. If they say, you know what, I don't know, because sometimes even when we're trying to do a speedy trial, or sometimes because of a school break or summertime or whatever, we could be going to trial on something that happened months ago and people could have forgotten that. That's normal. So you talk to someone, you ask them, because you have all of these questions prepared and they just don't remember. Then what do? Do you have to just take that and say, oh, they don't remember? There's something in the law called refreshing your recollection. It's really easy. You ask them, well, did you prepare? Say it's a police officer and he just doesn't remember what someone said to him, right? And say it's the defendant and they had some sort of omission that you definitely want to get in because it's a statement against interest, so it's definitely admissible. You would ask them, you prepared a report when you made the arrest, is that correct? Yes. Okay. Would it refresh your recollection to review that report that you wrote in conjunction with this case? And hopefully they say yes. Prep. Tell them, if you ever don't remember anything, don't worry, I can refresh it. Then you get the opportunity to show them that report, let them read it, refresh the recollection, and then you take it back and then ask the question again. Okay, what did he say? And so you're going to let that in. So we make it sure that you know that anytime a witness doesn't remember something, that you can refresh the recollection. So in cross, if there's a previous statement that was written, you can refresh someone's memory with anything, whether they wrote it or not. So if you're on cross and they're trying to back out of something, you could say, well, would it refresh your recollection to read through what happened that day? Show it to them. And then, say, impeach previous statement, refresh memory. Make sure you have all your techniques there. That on cross get a little more tricky. Remember, it's a fine line between being a zealous advocate and being a jerk. So just don't cross the line. But definitely get the information out that you want out, and you have a lot of tools at your disposal to do that. Okay. So let's talk about controlling witnesses really quickly. All the witnesses are going to do what they want to do. Just like everyone else, people do what they want to do. They're going to answer the questions in the light most favorable to themselves. Make sure that you know that. Just like if you were up there, okay? And I always use the example of getting in trouble with your parents, right? And you're under scrutiny and questions. How do you react? That's the way that person's reacting on that stand, okay? So make sure just to have control. If they are not answering like Mike said on cross, it's a yes or no question. If you can't get them to answer yes or no, you can look at the judge and say, Your Honor, can you please direct them to answer the question? And they will, okay? They'll help you out, okay? So yeah.
Well, we've got there's some techniques that we'll teach you. It's better to teach you guys in person because you get to practice them. And maybe the homework assignments, they may have some in there when you read them, you'll find out that they may have some to practice. But there's definitely some methods that we have that we can teach you, because you don't want to go to the judge too soon, because you want the judge to think you're credible too. And if you have to go to the judge every single time someone's not going to ask the question, the judge may be like, well, you're the attorney here, control your witness. So we'll teach you some methods on how to do a basic witness control. And we will also teach you this week how to do basic impeachment. So we have a lot of tools that it's easier to show you guys in person than it is to do over a video like this, because it's a little complicated. And then you'll get to see me be a difficult witness more accurately. You get to see Felicia be a difficult witness. I've questioned Felicia on in practice before, and
yeah, and just
it's
like I
unique.
said with refresh, because I like to play devil's advocate. So
Yes.
here we go. Just like I said there, you can refresh your memory, you can impeach anyone. It doesn't have to be something they wrote. Someone who was there can be impeached by either a statement that they made that was recorded by someone else, or by the report written by the police officer. I got to the scene and this and this and this. So just make sure that you know it doesn't have to be admissible to refresh someone's recollection or impeach them. I think that's the bottom line.
Yep.
Because I'm sure that when you guys went over what was admissible and unadmissible, relevant and not relevant, and hearsay and not hearsay, and hearsay exceptions, that you know that if you are refreshing someone's recollection or impeaching them, that those rules don't apply because you're not admitting it for evidence.
That's correct.
Right.
So speaking of evidence and getting things out or keeping things in, we're going to go over some objections now.
You know what I learned in practice is that tricky is not a basis for an objection. You have to have a real basis for an objection.
Yeah. Also, objection, this is really damaging to my case, is also not a valid objection.
It's not.
The judge,
it should be.
Judge didn't find it as funny as I did. So there are a lot of objections, and a lot of them are actually based in evidence. But it's funny how you're really only going to probably use, I'd say, what, about 5 or 6 are the big ones. In fact, we have our stuff written down to teach you guys, and I'm looking at it, I'm like, haven't used that one, haven't used that one, haven't used that one. So it's kind of funny how you really only use a few objections, but you need to know them all at the same time, because that's how you earn your money.
And so the phrasing of the question is a big one. You can say objection, confusing or ambiguous question, or compound question. There's a bunch that are applicable to the question itself. Yes. And like I said, you did all this prep. You know this case in and out. This happens to real attorneys doing real trial work, where in your head it made sense, but as it came out, it didn't maybe make all the sense. So it's okay to say, objection, that's an ambiguous question. Or I asked you 2 things at once, because one of some attorneys' favorite things to do is to say, well, you were there on that day and you committed the crime, right? And all the person heard was, you were there on that day. Oh, yeah, And well, guess what? You just admitted to the whole thing. The question has to be completely right. It's like a true or false on all those standardized tests you guys take. The whole thing has to be right, or the answer is no. So you can help out your witnesses with those objections.
How many times am I allowed to ask a question?
Just the once, if it's answered. So if it hasn't been answered, that's the rebuttal to asked and answered. That's a basis for an objection too. It has to be asked and answered already.
The second part to me is actually, I've seen a lot of people use that objection. It's like, well, Your Honor, they didn't actually answer my question. So yeah, that's where paying attention comes into play, because they may not have actually answered it.
Another one is, so why do you think she did it? Is there a problem with that question?
Yes. That is an objection called calls for speculation. And that's the best way I learned to think about this. If you're asking someone to kind of enter somebody else's mind and make a guess, most of the time that's called speculation.
Yep. And another big one is, remember we talked about foundation kind of has 2 meanings. So if you feel like you don't know what they're talking about, it's objection to foundation. Like they didn't lay the proper foundation for the exhibit, or you don't know what the date in question is because they didn't bother to give it to you or ask about it, then yeah.
So sometimes with foundation you want to let it go though, and it's very rare, and this is something you want to talk to your senior attorney about, because if it's basic questioning and you know the answer is going to get it anyway, you work for Smith's, don't you? Do you really want to object on foundation when you know they're just going to ask the question again? Probably not. But if it's bigger stuff, it's definitely important. And I'll tell you what, personal story. My first trial, I was so nervous. I wanted to get all the facts in, and I focused on the facts so much that I got objected to every single question on foundation because I forgot to do it. So it happens to the best of us. And you want to pay attention because objections aren't always used. Even though you might lose your objection, sometimes it's a technique to use to throw the other side off. If they're in a rhythm and they're on their game and they're just beating your witness up, if you can throw an objection in there just to get them off, or at least test them to get them off, you want to, foundation's a good one to use, or relevance is another one, is a big objection.
Because it's not relevant. It doesn't matter.
Yeah.
And you get to argue about whether or not something matters. So that's pretty good.
Yeah, and it slows them down. I don't do that because it's not my style, but almost every other attorney I know does that because you want, if the other attorney isn't on their game and you break their rhythm and all of a sudden, I don't know how to get back into it, then you win that.
And that's where if someone objected to you and you need a minute to get back in your rhythm, take that moment of court's indulgence. Guess what? I'm smarter. I can take a minute and get back into my rhythm. If you need the minute, take it. Then the last really big objection is your hearsay. Hearsay is exactly what it sounds. I know you guys did this last week.
That's fine.
But it's you hear it and then you say it. So if any question was, what did she say? What did he say? Guess what? It's hearsay. And you get to at least start that objection. And then guys can get into the nuances of what is non-hearsay versus what is hearsay, but there's an exception for it. So I know that you guys went through all of that, so we won't.
We did a little bit, but I will say this. Hearsay objections are a good one to test the opposing attorney on what they know. So for perfect example is party opponent. We discussed last time about how a statement made by a party opponent is technically not hearsay. That doesn't mean you shouldn't make the objection. Make the objection. If the other side can't make the argument, well, it's a statement of a party opponent, then it's not coming in. So sometimes it's just a matter of you were going to make an objection that may not win, but if the other side can't make the argument, the judge will rule in your favor. So hearsay is definitely a good one to use because there's so many. I mean, there is an entire 2 chapters on hearsay exceptions and things that are not hearsay.
Mm-hmm.
I don't remember them all. I couldn't remember them all when I was in my evidence class because there's just that many, and some of them are just very intricate. So you make your hearsay objection. Make the other side work to get that evidence in.
Sure, absolutely. So those are objections, and we're running over, but we need to go over opening and closing statement. So opening statement, closing argument is really important that you know the difference. When you're in trial, I know we talked about opening arguments, closing arguments for the prosecution. When you're doing sentencing and trial by peers, very different. This is an opening statement. There's 3 basic components of opening statements. There's your greeting, introduce yourself, who you represent. Number 2 is your meat. Summarize the evidence to be introduced, including who's going to testify, in an organized, engaging, memorable fashion. Please don't put people to sleep during your opening statement because you are reading it or you're droning on, okay? Closing. Remind the jury that you're going to hear an argument after the witnesses and the outcome you want, okay? You will hear my co-counsel, Mike, come back and argue why you need to return a verdict of not guilty. Done. Okay. So there's some content and communication pointers for you in the materials that you're being given for the class this week. We're going to go over the big ones right now. Again, avoid legal jargon. Do use terms that people will understand. Remember who you're talking to, okay? It's a jury of your peers. Don't use a bunch of crazy legalese so they don't understand what you're talking about. Make sure to go through the law that the prosecution is saying that the subject might have violated, whether you're on prosecution or whether you're on defense. We need to set up what we're talking about. We need to know that. We need to know what we're dealing with here, right? You need to tell the story. My favorite line is the evidence will show, and then you get to say, the evidence will show this minor came through at this time and did these things. It's very, very important because you want to make sure to paint the right picture and frame it and develop the theory of your case, but not oversell it. Don't promise anything in your opening statement that you don't 100% know you can deliver on. And 100% deliver is a very high standard. So don't oversell. The evidence will show that they had marijuana on them on this day. Make sure you lay out the facts, but make sure that you don't oversell. This is super important. Make sure to use the future tense. Make sure to use, because things have not come out yet, right? Make sure to use persuasive language. Be brief, be concise, get to the point. Don't lecture anybody. Don't use this as an opportunity to show off your 50-cent words. Again, you will find that in trial by peers and in trial work, nobody really likes to hear your IQ or your 50-cent words or how smart you are. We all know you're very brilliant people. Okay, move on, right? Talk to me in a language I can understand it, because it is the story you're telling that's going to engage your audience, not big words that you're using. So you want to make sure to just lay it out. And this is your first discussion with the jury. They're meeting you. You're going to want to go ahead and give your theory of the case and kind of introduce your side. Any other major points that you want to?
Real quick, a wise Judge Sullivan, who you guys will all meet, that basically has always told me this: the trials are 3 parts. Tell me where you're going, take me there, tell me where I've been. Opening statement is telling the judge where we're going. This is what I'm going to show you. This is my case. And brief summary. So everything else Felicia said, but keep in mind, this is the preview. This is, coming attractions. Here's what's coming your way.
Right. And it's a statement, not an argument. It's a statement. Okay. After you had all these witnesses and you did all this great questioning, comes the closing argument. This, ladies and gentlemen, is an argument. This is the moment where you argue. You're basically saying, please vote for me. So you need to be as persuasive as possible. Again, there's 3 parts. And you always start the beginning with, thank you for your time and attention. I appreciate you listening to the evidence that's been presented. Thank you, okay? Recognizing that the jury's just sat through this whole thing. That's why closing arguments are the best to teach at the very end of the class, because it's a thank you for listening through all of this stuff, okay? That's the beginning. The middle basically is the meat of it, okay? What a closing argument is applying the facts that were elicited during trial to the law that's being that's at subject in this case. Okay, that's the middle. Applying facts to the law. Got it. And the end is the closing, where you kind of quickly bullet point the big things and then firmly state the verdict that you want them to return. Remember, nothing is as persuasive as reminding them, this is why you must what? Make sure they know what you want them to do, okay? Quick note here, prosecution does a opening closing, defense does a closing, and then prosecution gets a rebuttal. The only thing I need to tell you about the rebuttal is that it is limited to responding to what the prosecution or what the defense presented, okay? Because only the prosecution gets that rebuttal. Limited to what the other side presented. You're rebutting argument. You are not making up more. You're not going over other stuff. You're just addressing what was addressed in that closing argument from the other side. Again, same things as the opening statement. Good eye contact, good voice inflections, good pacing. Do not use legalese. Don't show your IQ at this point. Make sure to restate what the law is. Quote it if necessary. Apply those facts. And make sure to address any facts that maybe might not be favorable to your side. So you call what we call drawing the sting, right? So you want to, it's like a bee sting. You want to pull that out and make sure that you say, I know they're going to get up here and say this, but consider this, and give your facts that you elicited that support your position. And you go through and remind the jury of the required burden of proof. If you're on the prosecution, acknowledge the fact that you've got that bigger burden and go through, this is why we met the burden. If you're defense, remind them about that burden of proof and then show why they didn't meet it, right? Make sure that you remain credible. Make sure that you don't use words like we believe they haven't met the burden. Well, that's nice that you believe that, but I don't. So, okay, no. Make sure you always say, this is why they didn't meet. Anything that you believe, you want to state you are persuasively speaking. If it didn't persuade you, then it's not going to persuade a jury or your peers, okay? Make sure that you use that strong language here because it is an argument. Argue your side. Make sure to address any counter arguments that could pop up or did pop up from the other side so that you can address those and make sure you remain persuasive. Anything else?
Always, always, always end your argument by stating what you want. Even in a perfect example is a rebuttal. Even if you have nothing to rebut because you're going to pay attention and you're only going to rebut to things specific to the defense closing argument, at least just get up and say, Your Honor, we renew our request, or to the jury, it's like, ladies and gentlemen of the jury, we just like to remind you that, you should for X, Y, and Z, and sit down. So anytime you're getting up for an argument, you want to make sure the last thing you say is what you're asking them to do.
Absolutely.
Prosecution, your arguments are going to be a little more boring, but that's okay because you're like Joe Friday, who I just realized none of you probably know who that is. Just the facts. Here's the law. Here's how the law applies to the facts. Someone once told me it's like baking a cake. Here's the ingredients here's the directions for the cake. Here is why this cake is, here's where the criminal cake is baked. Here's every single ingredient. This is why you need to come back with a guilty verdict. Defense, you're there to poke holes. You don't need to prove anything. This is why this element has 3 crimes, and here's why that, even if you can only say one element defeats the crime. This is why this element can't be true. But make sure, no matter what, you're always your last thing is the ask. You must find the defendant, or even the justice demands you have to find this my client not guilty. That's where you can have a little bit of a panache on your argument, but make sure that's the last thing you ask.
Absolutely. Okay, guys, we went over. We're both very passionate about trials, so that happened, and I guess we'll see you.
We can knock 10 minutes off their homework, right?
No. You got 5 minutes for my criminal law one.
I tried.
Just do it faster.
Thank you for paying attention to all this. This will be a fun class on Saturday. There's going to be a lot of interactive stuff. You guys are going to get to practice questioning witnesses. So make sure you do the homework because hopefully everyone can get involved in this.
Yeah.
And I know we'll see you guys again live one more time, but thank you very much for sitting through all these videos. Yay. If you have any questions, as always, you have both of our email addresses that we gave you at the beginning of the course. Do not hesitate to ask questions. I will answer all your questions you send me, and most likely if I don't, I'll just send them to Felicia and make her do it for me. Thanks again. Hope you guys have a good rest of the week, and we'll see you on Saturday.
Yep, see you Saturday. Bye.